I'm Karen Friedman Agnifilo with Legal AF. Countdown to the first trial that Donald Trump will face before the election, the Manhattan DA's office. Criminal felony prosecution against him that is set to begin March 25th. My old office, the Manhattan DA's office, where I worked for almost 3 decades. That trial is starting, and the judge is finalizing his pretrial rulings after the parties have made numerous requests of the court and asked that the court rule on various things, including one that the judge just made a ruling on now, 2 weeks before the trial. Judge Juan Merchan, who is the judge who oversaw the Trump Organization trial in November of 2022, where they found, the jury unanimously found the Trump Organization guilty of 17 counts of tax fraud. That's felony tax fraud. And this particular case, Donald Trump is now charged with 34 counts of falsifying a business record in the first degree. Those are felonies in New York. And Judge Merchan oversaw that last trial and is overseeing this trial as well. And he's a very fair judge. He's a judge that I've appeared before many times. And Judge Merchan ruled on a motion for a protective order that was filed by the district attorney's office on February 22nd. That motion asked the court to restrict disclosure of the business or residential addresses of any prospective or sworn juror other than the counsel of record for either party. So this is pursuant to Criminal Procedure Law, Section 270.15, Subdivision 1A. So again, they asked for 3 things. Number 1, to restrict the addresses of any prospective or sworn jurors, right, to anyone other than the lawyers or the parties in the case. Second, the people, the prosecution, and they call themselves the people, right? It's not the government, which is what federal prosecutors call themselves. The people is the Manhattan DA's office, or any other state prosecutor in New York. The second request from the people was they asked the court to invoke its inherent authority to prohibit disclosure of juror names other than to parties and to counsel. So number 1, they want the addresses restricted and then the names restricted. So only the lawyers and the parties, meaning Donald Trump, would and the DA's office would have the names. So the rest of us wouldn't. Why are they asking for these things? To protect the jury and protect the jury from harassment, from threats, from all the things that we know has happened when Donald Trump has gotten involved in any cases, right, in the past. And they had a long, the prosecution, the Manhattan DA's office, in their motion cited all the reasons for these 2 requests, because there is a lot of examples of Donald Trump going after the judges, the court staff, the jurors, the prosecutors. He goes after everybody. And obviously, if he went after the jurors, number 1, how could you find anyone who would sit on a jury and subject themselves to this? But also, number 2, these are people doing their civic duty. They shouldn't have to be threatened or have their whole life turned upside down just because they're jurors in this case. So, right, number 1, restrict the addresses. Number 2, the names. And number 3, the third request was to ask the court to explicitly provide notice to the defendant, right? The defendant meaning Donald Trump, defendant Trump, that any harassing or disruptive conduct that threatens the safety or integrity of the jury may result in forfeiture of his access to juror names. He's basically saying, watch it, okay? We want to remind him, watch it, or you're going to lose this privilege that we're asking you to get. Trump and his lawyers filed their response March 4th, and shockingly, they consented to 1 and 2. I was surprised. I thought they were never going to agree to anything because all they ever do is disagree, but they consented to 1 and 2. And that, of course, you can predict if you've got both parties consenting, what's the judge going to rule? Of course, he's going to rule for those things. But Donald Trump, defendant Trump, consented to numbers 1 and 2. but asked, could we please expand, this restriction, or could we expand the access to the names and addresses to paralegals and to consultants, jury consultants. Basically, they're going to have staff doing research on jurors to see if they can find on their social media and elsewhere any hints that they might harbor some thoughts or things or prejudices or biases that would impact their ability to be fair and impartial to sit on this case, because that's really what determines who gets to be on the case. Somebody who can be fair and impartial. It's not about being a Trump supporter or anything like that, or being political. It's not about your views. It's can you put your views aside? Because of course everybody has them. Can you put them aside and be fair and impartial for this particular case and this particular defendant? And that's what voir dire, or the jury selection process, is all about. So they said, we want to expand the request. We consent to just parties and lawyers, but can it also be the staff of the parties and lawyers? But they also asked for can you please minimize any prejudice to the defendant by not telling the jurors that there could be this protective order, right? Because think about it. Imagine telling a juror, this defendant is so dangerous, we're not going to let anyone know your name or address, or sitting on this juror is so dangerous that we're not going to tell anyone your name or your address. That could make them scared for themselves, and to not be focusing on the evidence and not focusing on what's before them, but instead they'd be thinking about themselves. So the defendant, Trump, asked to minimize any prejudice to the defendant by not telling the jurors of the existence of these protective measures, unless the juror makes an inquiry. And then if they do, you provide a neutral explanation for instructions for the procedure. So be very neutral. Say, yes, we are not going to give your name and address out unnecessarily. That's standard. We wouldn't do that in any case, or something like that, to just keep it neutral. And so again, I think that's quite fair.
Here's a personal question. How'd you sleep last night? If you answered not so great, just okay, or don't ask, you're not alone. 1 out of 3 Americans report being sleep deprived. And your sheets could be the problem. The wrong sheets can trap body heat, leaving you boiling 1 minute and freezing the next. The solution? Cozy Earth bedding. I love that Cozy Earth's bedding sheets are incredibly soft and also breathable, allowing me to have the best night's sleep imaginable. It is my go-to set of sheets from my linen closet. I love them that much. Cozy Earth is life-changing luxury. Cozy Earth's best-selling bamboo sheet set is made from 100% premium viscose from bamboo, which makes them naturally temperature regulating and breathable. So you'll sleep more comfortably all year round. Cozy Earth sheets are uniquely soft and only get softer with every wash. Cozy Earth is the brand that made Oprah's favorite things 5 years in a row. Cozy Earth comes with a 100-night sleep trial, which means you have up to 100 nights to sleep on them, wash them, and try them out. If you're not completely in love, just return them within 100 days for a full refund. And all of their products also include a 10-year warranty against defects. Whether it's their luxury bedding, ultra comfortable loungewear, plus bath towels and more, you'll love shopping at Cozy Earth. If you've never tried Cozy Earth, I got some awesome news. You can save up to 35% off Cozy Earth right now. But hurry, this offer won't last. Go to CozyEarth.com/legalAF and enter our promo code LegalAF at checkout for up to 35% off. That's CozyEarth.com/legalAF, promo code LegalAF. CozyEarth.com/legalAF.
And of course, the defendant objects to number 3 altogether. This reminder, right, that he could lose his privilege. They say, we agree to 1 and 2 with these slight modifications that I just explained, but we disagree with number 3. And of course, the court granted number 1 and 2 because everybody agreed. And as to number 3, he said that I'm going to reserve this for when I address the people's gag order motion that I still have at bay. Because don't forget, the government asked for a gag order here. And he said, however, I'm going to remind the defendant and all parties to this action, including the lawyers and counsel, of the court's prior instructions on April 4th, March 4th, and May 23rd. And then he goes on to list most of, or read from these transcripts. He's clearly putting Donald Trump on notice, essentially, that you do anything, you step out of line, you have been now notified on March 4th, April 4th, and May 23rd. And then again, I'm reminding you of those three, plus here in this order, that you have to be careful, right? I am telling you, refrain. I'm not infringing on your First Amendment rights. You're running for office, but defense counsel, speak to your client and anybody else you need to remind them to refrain from making statements that are likely to incite violence or civil unrest. Please refrain from making comments or engaging in conduct that has the potential to incite these things. So he does that. And then the court addresses Mr. Trump directly on April 4th and says, Mr. Trump, you have the right to be present at every stage of the proceedings. And this is obviously very, very important and an important right, because it allows you to assist your attorneys in their defense of you. And it allows them to consult with you. And if there's a jury, they can see you present, et cetera. So for all those reasons, I'm sure you can appreciate the right to be present at your trial and your proceedings is important. And I'm required by law to inform you that there are ways you can waive your right to be present at these proceedings. Specifically, I'd like to refer to two specific areas. You can waive your right to be present if you voluntarily absent yourself from the proceedings. And if you find Mr. Trump says, yes, I understand that. And then he says, the second way you can lose your right or waive your right is to become disruptive. If you become disruptive to such a degree that it affects my ability to preside over this case, I do have the authority to remove you from the courtroom and continue in your absence. Do you understand? And Trump said, I do. So they puts this verbatim transcript in this order, and it goes on and on where it's all the court's reminders, right? For all of the things, all of the times the judge has told the defendant over and over and over and over again. So he's basically setting up a record to make sure that Trump is on notice that if he becomes disruptive, the judge is going to step in. The judge also added something in here that no parties asked for, but he felt the need to include this in the order. He said the parties have not requested, and this court has not agreed to close the courtroom during jury selection or any other time during these proceedings. So I think he was signaling that yes, you can all come in. Yes, you can all see what's going on, but you are not going to learn the jurors' names or identities, nor I'm going to let you publish them or in any way put them in danger. And then he ends this with an order that the people's motion for a protective order restricting disclosure of business or residential address of any prospective or sworn juror other than to counsel of record for either party is granted. And further, it is ordered that the people's motion to prohibit disclosure of juror names other than to parties and counsel is granted and modified at the request of the defendant to expand the universe of those permitted access to the names to include the staff and consultants of the respective parties. It is further ordered that the people and counsel for the defendant shall jointly submit to this court no later than Friday, March 15th, proposed neutral explanations and limiting instructions the court may give to the jury to minimize any potential prejudice to either party. If the parties are unable to agree on language of the proposals, then each party is to submit a separate proposal to the court no later than Monday, March 18th. It is further ordered that the clerk of the court, Christopher DeSanto, shall implement the necessary measures and take all necessary steps to ensure compliance with this decision and order. And it is further ordered that the people's motion for this court to explicitly provide notice to the defendant that any harassing or disruptive conduct that threatens the safety or integrity of the jury may result in forfeiture of defendant's access to juror names is reserved pending this court's decision on the people's motion for an order restricting extrajudicial statements, which is basically a gag order. And in the interim, defendant and all parties to this action, including counsel, are reminded of this court's prior instructions from April 4th, March 4th, and May 23rd, 2023. The foregoing constitutes the decision and order of this court, signed Juan Merchan, Judge of the Supreme Court, acting Justice of the Supreme Court, Judge of the Court of Claims. It's just what his title happens to be. So stay tuned, and I'll keep you informed on all things Manhattan DA's office. I'm Karen Friedman-Agnifilo. Join me and my co-hosts for Legal AF every Wednesday and Saturday.
Hey, Meidas Mighty, love this report? Continue the conversation by following us on Instagram @MeidasTouch to keep up with the most important news of the day. What are you waiting for? Follow us now.